this is you for the end, right before we get ready to take questions. Hi, Vicki Bell here, and welcome to today's Tuesday Tip on Facebook Live. Today, in celebration of the last week of Fair Housing Month, we're going to discuss Section 504 of the Rehabilitation Act of 1973. Often the law is simply called Section 504. Section 504 is not the only law that prohibits discrimination in programs receiving HUD funds or financial assistance. We encourage you to look on HUD's website under the People with Disability website to look at the other programs and the other laws that affect people with disabilities. Section 504 prohibits discrimination on the basis of a disability in any program or activity that receives financial assistance from any federal agency and or companies or agencies like the Department of HUD, the Treasury Department, and departments of that nature, as well as any programs conducted under the federal agencies, including HUD. We're going to define disability as any person who has a physical or mental impairment that substantially limits one or more major life activities, such as walking, running, talking, even the ability to move your limbs. Any impairment, HIV infections, visual infections, vocal impairments, anything other than some drug addictions. Now, if you're in a drug program, then you're not covered under the 504. It includes things like walking, breathing, hearing, seeing, all of the life benefits or the life activities that one would have to do. Today, as we talk about 504, we're going to talk about reasonable accommodations and reasonable modifications. As you know, a reasonable accommodation affects the program or the policies, the structure of the program. A reasonable modification affects the structure or the dwelling. Example of a modification. A person might need a seeing eye dog, or a person might need an assistance animal, or a person might need the ability to have and to use a certain parking space. An example of a reasonable accommodation would be a structural change, to build a ramp or to tear down a wall on the inside to make the door wider or something to that effect, something that will affect the structure. As we go along, I do want you to understand that even though a person with a disability has the rights under 504, they don't have the right to be admitted to your property over any eligibility requirements. They have to qualify, they have to be eligible to live in the property. Along with that fact, the owner agent can get third-party verification to make sure that the person has a disability and that the accommodation or the modification that they're requesting has a nexus with that disability. HUD says that you don't have the right to ask what the disability is, but you do have the right to verify that there is a disability. With that said, when you send out your third-party verification, you want to make sure that you ask the right questions that will give you the right answer. Also, on your application, you want to make sure with the application that you ask applicants if they need a reasonable accommodation or a reasonable modification. With your recertifications and your recertification application, you want to ask those same questions. One thing I do want you to keep in mind is that 504 doesn't have a particular procedure for the disabled person to ask for any of the accommodations. And with that being said, it can be a verbal request. However, we suggest that you get it in writing because it helps take care and protect both parties. Make sure that your tenant selection plan and that your house rules cover cover the fact that they need a reasonable accommodation and that your company is willing to provide reasonable accommodations or modifications. Now, HUD says, or 504 says that there are two reasons why you cannot grant an accommodation or a modification. One being it creates an undue substantial financial burden on the property, or it alters the structure of the program so that you can't get it structured back. And I would advise you that if you want to use one of those as your scapegoat, please have your estimates. Please know that they will investigate to make sure that the property can afford this request or cannot afford this request. So I urge you to do that. With that being said, I'm going to take questions from you today, and I have a disclaimer. Yes, my disclaimer before I begin taking questions, I want to caution you that the answers you will receive today are based on interpretation guidance provided by several sources that we've used, including but not limited to the Section 504 frequently asked questions, the HUD case studies that you can find easily on the website, and the published fair housing questions and answers. We want to remind you that the FHEO office says that each fair housing situation should be handled on a case-by-case basis. There's no one-all covering for whatever the situation is. Also, Navigate strongly recommends that you consult your individual attorneys and or legal advisors before making any fair housing decisions. Each company that employs 15 or more employees should have a 504 coordinator. Make sure that you have a 504 coordinator if your company employs 15 or more employees, and run things by that coordinator. I also want to caution you that the greatest disability issue lately has been the disability. That's the number one cause of the 504 incidents that are happening lately. Is disability. The second one is familiar status. But today we're only going to talk about 504 disability, reasonable accommodations, and reasonable modifications. With that being said, and the disclaimer given, we're open for questions.
Vicki, I have a question. A person in a wheelchair has found a second floor apartment in an older walk-up building. Can that person ask the landlord to put in an elevator?
The question is, a resident on the ground floor wants to know if they can occupy a unit on the second floor or third floor above the ground floor, and if management, the owner agent, has to install an elevator. And the answer to that is no. It's one of the things that's written in the 4350, that example is in the 4350.3 in Chapter 2. Number one, it would probably cause definitely an undue financial burden or hardship on the property to put in an elevator because, number one, you probably don't have a place for an elevator shaft. So it would also change the structure of the program. So that answer is no. However, if the resident wants to occupy a second level unit, although they have a disability, you cannot deny that. But you must make sure that you understand, and if I were you, I'd put it in writing, that they understand that there are no accommodations to the second floor other than the stairs. Now, if you are in a high-rise unit and you have an elevator, there is no problem. Next question.
A single male and a single pregnant female both are interested in a unit at a large complex. They both have great credit, and she has references from a previous landlord. He does not have a rental history or a landlord reference because he was a homeowner for the past 12 years. The landlord decides to rent to the man. Does that pose a problem?
Don't know if you guys could hear the question or not. This isn't a reasonable accommodation or a reasonable modification question, but we'll take it anyway. The question is that there are two people who have applied. One, they both have good credit. One has a rental history and one does not. Who would actually get the unit? This particular instance, as Lisa read, the gentleman, I think, was given the unit.
Yes.
And not the lady. And what makes the difference? What should make the difference in such a case as this is whose name was put on the waiting list first. Which application did you receive? Which completed application did you receive to determine eligibility in order to place them on your waiting list? And from your waiting list, you want to take people in chronological order unless there is a reason that you don't or you are not going to fill it. And you need to give an explanation on your waiting list as to why you didn't take them in chronological order. Two things come to mind. Number one, you're trying to get your quota. And the second thing is that you have a preference. Next question.
Okay, I have something else. A renter who's lived in the same first floor apartment for several years now needs a wheelchair because of a degenerative disease. The person submitted a request to install a ramp to their unit at their own expense. The landlord has not responded. A few weeks later, the landlord evicted the resident, saying the sister would be moving into town shortly and would be living there.
Okay, it seems that in this situation, we have a person who's living on your property, and all of a sudden, because of a degenerating disease, they need a wheelchair. They're requesting a ramp, and they're saying that they will pay for the ramp. First of all, in our properties, residents aren't allowed to make those repairs unless you can prove that it puts such a financial burden on management that they can't afford to. Then that's a result getting the resident to pay for it so that they could have the accommodation. The second thing is that when you receive accommodation requests like these, it's simpler to go ahead and make that modification to build that ramp, and that's what I would advise you to do. Of course, you have to consult with your own legal advisor. While we're waiting on questions to come in, let me tell you about a couple of calls that we have received prior to us taping the Tuesday Live. There was a call that we received where a manager wanted to know if she had to give a parking space to a resident. Mrs. Jones wants the corner parking space at her complex, not 3 spaces down, not 2 spaces down, not the space next to it, but the very corner parking space. And the manager wanted to know if she had to accommodate her by giving her and meeting that reasonable request. The answer was yes. I was able to show the owner agent where HUD had made a decision based on a case study, which means if by the time you get to a case study, somebody's gone to court and there is a decision that's rendered. The case study said or showed that the resident did get the third-party verification from her doctor that she needed a parking space that was close to her building. Now, the question was, did she need that particular parking space? In the suit that was bought, it was established that the resident gave out a breath. She literally gave out a breath in strength after X number of feet. And the distance between her parking space and her apartment was under the limited amount of footage or steps that she would have to take. So HUD ruled in favor of the plaintiff, in favor of the resident, because she indeed needed that. The extra steps would make her fall out, collapse, which could cause more injury to her. So my question, and we have a lot of questions, a lot of calls. We have a lot of calls from residents with resident complaints. Miss Johnson won't give me a parking space. I want a parking space. If you can get third-party verification that a resident needs an assigned parking space, my advice to you would be to go ahead and give them that parking space. Now, I had a manager in a class once that said, well, if that's the case, everybody's going to want a parking space and my whole parking lot will be assigned. I would say that if you have third-party verification that everybody needs an assigned parking space, then I would look into it. I would definitely seek advice from my legal advisor as to how many or which ones to grant. My thing would be to grant them all until the parking spaces ran out, if you have the documentation to support it. Any other questions?
Yes, Vicki, what about cases when a resident has aged in place or has become injured? They're now wheelchair bound, but they can't access the bathroom or the kitchen or their bedrooms. Is an owner required to make those door openings larger so that it's wheelchair accessible?
The question is, we have an elderly resident that's now wheelchair bound, unable to utilize the unit because of the disability and the wheelchair. The question is, should management or owner's agents make the unit accessible for that resident? And the answer would be yes. You should modify it in any way possible as long as it does not cause an undue financial burden on the property or a structural change. In some cases, we have extra wide wheelchairs. In some cases, you might not be able. I remember a case that there was a young lady in an extra wide wheelchair that she could get in the door. Management had opened the door spacing so the chair could go in freely, into her bedroom freely, but it could not get into the bathroom. The panel box, the electrical panel box, was on the wall that went into the bathroom close to the door. So management got bids, estimates, and everything to see about getting the panel box moved, but unfortunately, it was going to cost them too much. They'd have to rewire and restructure the whole unit. If at all possible, try to make the accommodations to make the units accessible, because that's what 504 is all about. Next question.
Sure, we have a question from Tracy. What happens when we give one tenant a chair glide and word gets out and now 10 other tenants come forward and request one? At what point can management say no, or do they have any rights as does the landlord have any rights?
Hi, Tracy. You know, that happens. If you'll remember, and I don't know how long you've been in the business, sometimes when someone got a new refrigerator, everybody wanted a new refrigerator and stove. The thing is, with the refrigerators, you might be able to put up a reasonable explanation as to why everyone could not receive one. But with a reasonable accommodation, it's going to be harder to prove that they don't need it. My advice to you in terms of the chair glide is that you had one person who received one. Now you have 10 people that want one. If they have the correct documentation from the third-party source that it is needed, and there is a nexus between their disability and the accommodation, the chair glide, then I'm sorry, you might have to put in 10.
That's a good question.
Very good question. Vicki, the need for a ceiling fan very often comes up on some properties. If a resident makes a request to install ceiling fans where there are not ceiling fans, must a management company honor that request?
The question, in case you didn't hear it, was about ceiling fans. The unit apparently does not come standard with ceiling fans, and there's a reasonable accommodation for a ceiling fan. Should management honor that request? My answer to that would be yes, by all means. The thing with ceiling fans is that they circulate air. If you have the third party, again, verification that the resident would benefit from the use of a ceiling fan, why not install it? You know, some people have breathing problems. Some people have problems about scents, gases, odors that affect them differently than it might you. By all means, I would say install the ceiling fan. You know, I have night sweats. I think I need a ceiling fan too.
Vicki, a question for Megan. Going off a previous question, if you have 10 additional requests for chair glides submitted, when does it become considered a financial burden on the landlord to complete those requests for reasonable accommodation?
Okay, Megan's piggybacking on the other question about the chair guides and the cost. And when does it become unreasonable? It becomes unreasonable when you produce documentation that the financial burden is just too much for the property. And Megan, let me go a little further by saying that sometimes FHEO will ask you for proof, or what proof do you have that this is creating a financial burden for you. They'll look at your reserves for replacements. They will look at the your budget. They'll see how you budget. What are you doing with the funds for that property? If you can prove that it causes the property an undue, unreasonable amount of money, a substantial financial burden, then that's all the proof that you need. You can stop at that 10 because we can't afford to do anymore. But I caution you to consult with your legal advisor and make sure that you cannot do anymore, because one thing about fair housing cases, all a plaintiff has to do is complain, and that triggers the investigation. And once the investigation is triggered, your company, your firm, managements, owners, and agents have to find legal representation to help them, what's the word I want to use, to help them fight the battle of saying no. So just make sure you have all of your ducks in a row and that you do have a reason and you can prove that it creates an undue financial burden on the property. Next question.
Vicki, another question. Family property, the mother is now wheelchair bound. Is it a reasonable accommodation to provide them with a fridge that has the freezer on the bottom versus the top?
Great question. Hadn't heard that one in a long time. In case you didn't hear the question, it's a family property. And on this family property, all of a sudden the mother has become wheelchair bound, and the handles on the refrigerator or the compartments on the refrigerators need to be changed for her. The question was, is it unreasonable for her to receive a refrigerator where the freezer is at the bottom and I guess the regular refrigerator is at the top? Not an unreasonable request at all, especially if the resident is bound to the wheelchair and can't reach the freezer. What you want to keep in mind is that by affording your residents these accommodations, you're helping to protect them, their health, their safety, as well as your property against any suits. If at all possible, I would say to get her a refrigerator that she could use. It would be the same thing if she was in a unit that was accessible. Usually in accessible units, the cabinets are lowered, the closets are lowered, the handles are one lever handles. It's easy for a person with a disability to be able to live, and that's the whole purpose of 504, is to make sure that a person with a disability is able to live and enjoy their unit just like everybody else.
Vicki, would that also apply to stoves where the knobs are on the front versus the top or the back?
Very good question. The question was, does it also refer to stoves where you have the stoves who have front-facing knobs that are lower opposed to the knobs that are on the back of the stove, which the resident has to reach over, especially if they're wheelchair bound? There's a case, if you Google HUD fair housing cases or cases with disability on your website, there's a case out there where a resident was burned because the eyes on the stove were hot and she had to reach over the stove in order to turn them off, and had made a request for a stove with the front eyes lowered that she could reach. reach? And I would say yes, Lisa, by all means, because that could be a great safety feature. Not only could the resident benefit from that by not getting burned or injured, but also the property could by something not catching on fire and 2 or 3 units going up as a result of the disabled resident not being able to reach the eyes. Next question.
Sure, we have a question from Luana. Luana, could you offer a person a handicap accessible unit if you have one and not have to do any modifications to the room that they are presently in?
Good question, Luana. And the answer is yes. By all means, you want to offer the accessible unit first. But in some cases, a resident might be in a unit and did not have a disability when they moved in. You could also, if you have an accessible unit available, you could offer them that unit opposed to making repairs or conditions to an existing unit that they might be in. But what you need to keep in mind is it is the resident's choice. But as we say in this industry, document, document, document. Document the fact that you offered her an accessible unit to meet her needs. And that's the reason the accessible units are there in the first place. But remember, she might not have become disabled when she first moved into the unit, so now she knows her neighbors on both sides and she just loves them, she enjoys them, she trusts them, she feels safe, so you might still have to look at making an accommodation for her.
I have a question. What if you suspect someone is mentally ill?
The question is, what if you suspect someone is mentally ill? My answer to that would be, how can you suspect someone is mentally ill? You can't look at a person and tell their illness. You can't determine unless you are a certified physician, and I mean just going beyond being a doctor, someone who deals with mentally ill patients all the time. If you were to Google the Fair Housing website, you will see that the mentally ill are protected under 504. The owners and agents are not to make any assumptions. They're not to be threatened or afraid to rent to a mentally ill person. And because most of the times they're on medications and they have people who are seeing at them. So my answer would be, I would not refuse a person who came into my office an application or admission because they looked mentally ill to me. Again, before we close, I just want to tell you that these were just based off case studies that we looked at. To consult with your own legal attorney or your 504 coordinator on any questions that you have. Now, the questions that you all did not bring up were assistance animals. I just want to throw that in there for you right quick. Remember that assistance animals are not pets, and you cannot treat them as such. The biggest case studies, even veterans coming back from the war needing animals for support, comfort. And remember, the animal doesn't have to be quote unquote under the term service animal. It could be an emotional support animal, a companion animal, an assistant animal, a therapy animal. They are not pets, they're considered animals.
Vicki, we
Yes.
actually have a question. Tracy wants to know, if our lease states that certain animals are not allowed, do we have to change our policies for this accommodation?
Tracy's question is, if their lease says that certain animals are not allowed, we'll say Rottweilers, for instance, do they have to change their lease? Under the 504 accommodation, there are no restrictions on size or breed of animals. There's no restriction on what type of animal. It could be a monkey or a donkey. There are no restrictions. However, if your state or local law has a restriction, if your city imposes that Rottweilers can't live in apartment complexes, or if your insurance requires that you pay additional insurance, those are things that you want to seek legal advice over. In some cases, remember that all cases are handled on a case-by-case basis. There's litigation out there where some cases, even though the owner's agent's insurance company said, we're going to drop you, we're not going to write you, HUD says, we'll find you another insurance carrier. There are some cases out there where the city restricted certain breeds to be around children. You need to look at it on a case-by-case basis, and in those cases, you do need to seek legal advice. That seems to be all of the questions for today. We're going to wrap up. I want to thank you guys, and we look forward to seeing you next Tuesday. As you know, April showers bring May flowers.
We got a question.
Oh, we got one last question.
Bill wants to know, our facilities don't allow pets of any kind, including service animals. We have group homes of mentally ill residents. Can we do this?
Bill says that his property does not allow animals of any kind, including service animals or assistance animals, and he wants to know, can he do this? Bill, I would say no. Unfortunately, apparently you have not been challenged. His clientele is a mentally ill group home, and the structure for group homes is a lot different. I would ask you, or I would advise you, to consult with your legal advisor, but there's nowhere in the 504 regulation that gives lenience to a group home. There's nowhere that I've read or investigated or seen where group homes have a leg up over the 504 regulation. You can be thankful it hasn't approached itself yet, but you are wise in seeking advice to find out before it does. Okay. Last time you guys sent us emails after. We'll be glad to answer some emails afterwards. We want to thank you. We want to tell you we're looking forward to bringing you blossoms of flowers and bouquets of flowers in our next Tuesday tips, which will be May, because the April showers are going to bring you guys great May tips. Thank you, and we look forward to seeing you and be with us again.